Probate Court and You. My name is Owen, Eagan, and I'm the West Hartford probate judge. Today we're here to talk about what happens with your real estate when you die. We have two distinguished guests who are willing to cooperate and provide us with information today. They are both experienced attorneys in probate law, both with over 30 years experience. First is Attorney Charron. Attorney Charron is the founder of the Charron Law Group, which is over 17 years old. She's located in Bloomfield, Connecticut. We also have with us Attorney Davidoff. He is our town clerk, the keeper of our real estate records, and also a practicing attorney. And as I said, both have over 30 years experience in the field of probate law. So welcome, Marianne.
Thank you.
And welcome, Leanne.
Good morning, Judge.
Thank you very much for being here. I really appreciate your being here and helping me with this. So we get right into the topic. I would like to talk about what happens with your real estate when you die. And maybe Marianne can start and tell us there's different types of estates. Different types of ownership of real estate. One is joint with rights of survivorship, and one is solely owned. Yep. Can you begin, please?
Yeah, sure. So generally when people purchase real estate, right, so we purchase it either in our individual capacity, and sometimes, particularly if we're married, we purchase it with our spouse. And typically, when you purchase property with a spouse, it's joint with a right of survivorship, which means that whoever's the survivor gets to keep the property. And one of the things that we as attorneys in probate have to deal with regularly, and Leon, I'm sure you have to deal with it from a recording purpose, is usually people think that when they're in a married couple, when the first dies, because the other one gets the property, that they don't have to deal with probate. And we know that's not true. And I think, Leon, you have to deal with that on a pretty regular basis.
Absolutely. Probably at least once or twice a week, people will come in and they'll mention that their spouse passed away, and they ask us, well, can you just draft up some document that's going to show that I am the owner of the property? And our staff has to explain that it's not like a car when you just change the title. You need to go to the probate court, and you need to get appropriate documentation to be filed on the land records to give third parties notice that somebody's handling the affairs of the estate. And when the whole thing's wrapped up, that the court has determined that there's no estate tax due, that there's no probate liens, and that the property has now vested in the surviving spouse, if that be the case.
Well, actually, title vests upon death immediately by law. But in order to confirm that, we have to file something on the land records, which is a certificate of devise. And that's exactly right. People make that mistake that they feel that they don't have to do anything if they own property jointly with their spouse with rights of survivorship. So it's interesting that you have that problem.
Right.
In probate.
And what's most interesting is all the documentation that comes from the probate court, right on the bottom, Judge, says, please file this document on the land records where the property is located. Yeah. And I don't know if it's when the people receive the documentation that they don't open up the envelope and they think everything's done, they paid the fees, but they never seem to complete the entire circle of getting everything done. And more often than not, they'll come in and they'll say, well, there seems to be a problem here. And they'll have their folder, and I'll say, well, you need to record this document, and this will complete the entire process. So
what I think is it's kind of a problem for probate is that most people, let's just keep focusing on the joint property that's held jointly. When one of the owners predeceases, just dies, and the second one has the property, they don't understand that you still have to go into probate court. Like, it's true, the asset is held jointly, which means it's not technically a probate asset, but that doesn't mean you don't have to go to probate court and file the documents that Leon was just talking about. And so, at least in my practice, and I'm sure we've all seen it, is that when the second spouse, right, the surviving spouse says, hi, I want to sell the property, right? We're trying to do a closing, get us ready for a closing. And you have to tell them, guess what? We have to probate the first spouse's estate in order for you to sell. That happens all the time.
Right, so what I like to explain to people is that if the property is jointly held and you're going to have a closing, you need the parties who are the owners of the property to be there to transfer the title to the piece of property. It's very difficult for somebody who's deceased to participate in this event. And it sort of clicks with them that they understand that.
Yeah.
And they're like, well, what would I need to do? And as Marianne rightfully said, you would need to have probated that estate of the decedent so that you're able to continue with this next transaction. It makes common sense, and explain to people that way, a light bulb goes off and everything seems to work out in the end. So it happens more often than we'd like it to happen, but if people are more proactive, we can probably reduce the amount of times that does happen.
And I would think that at the probate court level, what happens is that someone comes to me for a closing, and I have to rush paperwork through. And there's only so many times when you can, throw yourself at the mercy of your staff, right? It's like, can you rush this through? The closing is Friday, kind of thing. And so I think part of the reason why we were excited about having this program was to make more people aware that this process has to occur and to make things easier at the level of the court. So
our court tries to accommodate in those situations and tries to do a tax purposes only estate.
Correct.
If at all possible, in a week or 2 weeks, if it can be done, so that the closing can go smoothly. But it doesn't always work that way.
I know.
Try and do it. I've had that same experience in my private office, where you're trying to close on a piece of property and you find out that one of the spouse's estates was not taken care of properly.
Yep.
One way we try and deal with that is we get the title search in early and we find out what's going on, and we can see, oh, the property is still in the name of the deceased spouse and the living spouse.
But particularly in the last few years since COVID, there have actually been a lot of cash sales, right? So the normal process is someone would get a mortgage, and we would have a little bit of time to be able to respond. Right. But with these cash sales, they happen so much more quickly. And by the time we get the title search, the buyer wants very badly to get into that house. Right. And it puts a lot of pressure on us. And you did mention something called the tax purpose only estate.
Yeah.
I don't know if most people know what that is.
Maybe you can explain it, please.
Okay. So we were just talking about, when people own property jointly. And so when there is someone who dies who owned not just real estate, but had other assets, you still have to file a document that's called the 706 NT. NT means non-taxable estate. And then, but there are no other solely owned assets, and there's a form for a tax purpose only estate. So you have to have the death certificate, your 706, a will if there is one, okay, and identify what expenses there are, what the assets are, and you have to pay a fee, perhaps not a tax, a fee to the state of Connecticut.
The fee happens to be based on the number of the value of assets in the that are mentioned in the 706 NT.
That's right. That's exactly right. So that's what a tax purpose, those are the documents that have to be filed in order for Leon to get his talismanic document that says that essentially we are free and clear to sell the estate. That title is good.
I think people need to understand, because there's a misconception that a lot of people are hearing, well, you avoid probate. You can't avoid filing the 706 NT.
Right.
And NT means non-taxable, as Marianne said,
yep.
because you're usually below this threshold as to a dollar amount as to what would make it a taxable estate.
Yep.
So, and the fees that are collected upon the computation of the 706 NT are what are used to fund the operations of the probate court. So it's essential in that respect. So I like to explain to my clients, we're going to be getting together and we're going to talk about this 706 NT. You're going to hear that number a lot, 706. Don't get scared by it, but it's part of the entire process, and it's an important part of the entire process so that we can get the fees paid to the probate court, we can get the appropriate documentation sent to the town clerk's office for filing for the land records, because you will not get the documentation from the probate court to file on the land records until those probate court fees have been paid.
Right.
So that's very, very important that that step not be missed.
Right.
And you want to put that certificate releasing the liens on the land records, so
Yep.
you can tell the world, my title is clear and I can convey it.
Yeah.
So,
Yeah, because there's not going to be a closing that
Right.
takes place without it, unless there's tax clearance. You're absolutely correct.
right.
Mm-hmm.
I think they call it an inchoate lien, which is an interesting word, but
Yeah.
it's a lien that affixes on the property the minute someone dies. It vests in the heir, whoever is going to receive the property.
Right.
Property automatically vests, but this lien also attaches, and it has to be removed so that the buyer, whoever is going to take the property, knows it's free and clear, and I don't have to contend with
Mm-hmm.
your spouse's estate or your estate or something else.
So if you see in your file a document called PC 258, which is a certificate releasing liens in a non-taxable estate, that's what we're talking about. That needs to be filed on the land records. And it's a one-page form. Currently, it's $60 to file it.
Right.
And it gets filed immediately and recorded, and it's effective.
And what you were saying earlier, Leon, was that sometimes people they actually get the form, the probate court form 258, and they keep it in their file and they fail to
Right.
file it. So they've really accomplished what they needed to accomplish. They filed with the probate court. They filed the 706 NT that Marianne Charron had talked about. They've got what they needed from the probate court, and then they just failed to go the extra yard and file it with you.
That's correct.
Yeah.
Right.
So if you have any of those forms in your file,
Don't visit them.
you should go see it. Attorney Davidoff, and he will help you.
$60.
Yeah.
You have to pay a $60 fee.
That's the recording fee.
It's kind of interesting. People always ask, well, can you waive it? And it's not a waivable. It's not discretionary. Unfortunately not.
Yeah.
Right.
You did mention, Marianne, you talked about people coming to court with various forms when they want to file. You talked about bringing a will. What happens if they don't have a will?
Well, I mean, you don't need to. Well, for a tax purpose only estate, it doesn't really matter if you had a will or not, right? Because somebody else is inheriting the property. Now, obviously, if it's a solely owned asset and someone doesn't have a will, then we have specific laws of intestacy that tell us who gets the property or who gets your assets. So that would be, if you're okay with that, then the state will tell you who inherits and in what capacity someone can inherit.
So if a husband and wife own property, it's jointly held
Yeah.
with rights of survivorship. Where will the property go?
Well, it goes to the surviving spouse.
Okay.
So that's an easy one, and you don't need a will. And this gets into
But
we've
if you
had
have
this.
a will, you need to file it,
You
correct?
do need to file it. You're supposed to. You have actually, I think it's 30 days within which. So there is a statute that says that if you are in possession of an original will for somebody, you are required to submit it to probate court within a certain period of time. What a lot of people don't understand is that a beneficiary designation will always trump what's in the will. So if your will says Marianne gets everything, but your surviving spouse co-owns the property, I don't get anything. Your surviving spouse will get it. So, and that's why I'm saying if it's a jointly owned piece of property, it doesn't really matter what the will says, but it is important to provide the court with your will.
Right.
So,
And if you die owning a will, then you die testate.
correct.
If you die without a will, you die intestate.
Yeah.
And Attorney Charron just pointed out that you will use the statutes of intestacy to determine where the assets go.
Right. So the surviving spouse usually gets 50%, and then if there are children of the spouse, of the two spouses, then they would get the rest. But there's a whole list of what ifs. What if somebody had a child
Right.
not of the marriage, and what if this, what, so like I said, if you're fine with what the state wants to do, then you don't need a will. If you're not fine, then you better have one. So
I think it's always wise to have one.
always.
You don't want the state to dictate where your
Mhm.
assets will go. And you also would like to dictate, you would like to control who manages your affairs at
Absolutely.
your death, rather than have the state tell you or the court tell you who's going to manage your affairs. It's better to pick that person to be your executor.
And so we started talking about with joint with right of survivorship,
Right.
but there is also a way to hold property, and it's called tenants in common. And so if Leon and I, as partners, owned a piece of property, but he wanted his family to inherit his share, I wanted my family to inherit my share, we would hold the asset as tenants in common. And so I was going to say, what if Leon died? No. What if I died? Okay. Then that technically is treated as a solely owned interest in real estate. And that is subject to probate. My interest is subject to probate. And so it would never not be a tax purpose only estate between the two of us. And we do have to have a full process by which that asset is probated. And the judge is correct. Even though title technically vests, into whom I designate upon my death, there is a process by which, the court would then eventually issue a certificate of devise to whoever my heirs were.
And that confirms it for the world. And it's recorded on the land records with
Mhm.
Leon Davidoff.
And it's another one-page document that costs $60 to file, but it's very, very important that that document be filed and recorded on the land records.
Absolutely, because when one does a title search,
Yeah.
it would be like, well, if Marianne is no longer living,
Mhm.
what happened to her?
That's right.
Who got it, and what was the determination?
Yep.
And that certificate of devise would clearly indicate who was the holder of that interest at this point.
Right.
But when you do an entire estate, there's notice to creditors.
Yes.
It
Yes.
takes 5 months after the publication for creditors to come forward.
Yeah.
There's an accounting that needs to take place for the entire estate. So
Yeah.
the court really says, try to wrap it up in a year.
Yeah.
That's optimistic these days in light of the fact that a lot of people aren't where they should be in terms of working, but that's always the goal, is try to get it done in a year's time. But with a short estate,
Yeah.
you can get those done much quicker.
What's the difference between a short estate and a long estate or a regular estate?
So a short estate has assets that have beneficiary designations on them and are able to transfer outside without probate court administration. So you're able to find a rightful owner for each of the different assets.
So
What is a beneficiary designation for the people at home?
Okay.
They may not know what that means.
So let's just say you own a life insurance policy, for example, and they say, okay, we're going to pay the life insurance proceeds out upon your death. To whom? Who do you want to designate? You want to designate your wife, your child, your children, a charity. And then there's also something known as a contingent beneficiary. In the event that that person predeceases you and you don't change your beneficiary, who would be your alternate? Who would be your backup? And those are very important to put beneficiary designations on accounts that are able to do that, whether it be savings accounts or banking accounts and investment accounts. It's very, very important, because if you fail to designate a beneficiary, your estate's going to become the beneficiary of that particular asset.
right.
How about retirement assets?
Well, yeah, so a 401k or an IRA or something like that, I think it's mandatory that you identify a primary beneficiary on them. But I like the idea of contingent beneficiaries, because then the asset immediate passes to the person you want to have that money. I just wanted to talk a little bit about, you called it a short estate? Is that what you called it? Short. I call it a small, short versus a full. But
small is the proper term.
Right. But what it means is that there are at least one asset, oftentimes it's the car, there's at least one asset that is solely owned, that does not have the beneficiary designations that Leon was just talking about. And we do have to file something that's called a PC 212. It's a small estate or a short estate form. And that is required in order to pass that asset. So you can't just go to DMV, for example, and say, I would like to put this car in my name. You have to have something from the probate court that authorizes the transfer of that property to you. Then you get to wait in line at the DMV. Okay, so right, I mean, that's what it is. But the asset limit, and I know that there was some intention or discussion about having that asset limit increase, but it's always been 40,000.
Always been 40.
Always been 40,000. So if there is some bank account that didn't have a transfer on death or pay on death beneficiary, or the car or some other asset, you're stuck having to go to probate court to probate that. It's not a lengthy procedure, but it is required. And then if you have a solely owned asset that is valued at more than 40,000, or if you own any real estate, you have a full estate. So yeah.
When you mentioned a motor vehicle, there's a couple of ways you can transfer the motor vehicle.
He's right.
Number one, it might be wise to hold the motor vehicle with your spouse, and that way, if one passes, the other spouse becomes the sole owner of that vehicle. It's easier to deal with at motor vehicle, and it's easier to deal with from a probate standpoint. Kind of like the jointly held property, the real estate.
That's right.
The other way, and I don't know if everybody knows this at home, motor vehicle has a form that allows you to designate a beneficiary of your vehicle on the form itself.
A lot of people don't know that. It is on the back of the registration, but DMV on its website does have a separate form.
Yes.
And you can identify somebody who you want to inherit your very nice car, right? So.
And generally, it's better to pass assets outside of probate, to have them go by way of a designated beneficiary.
It's easier. Yeah. I mean, look at all of us here are practicing attorneys, and we know the probate process. It's not horrible, but it is much easier for your heirs, for your loved ones, for the people who you want to get something, to be able to have immediate access instead of waiting. As Leon said, it can take about a year for an estate to settle.
So what would you file if you were dealing with a person who has solely owned assets, including real estate? What would you file? How would you start the probate process? You'd interview the client, correct?
Yeah. Well, you have a PC 200. So the PC 200 is the application to have the will, if you have a will, or have somebody appointed as the administrator if you don't have a will, to have the legal authority to do all the things that we were just talking about. And that's the first step. And the judge has to either, accept the will, okay, or, because sometimes you don't have to. Sometimes wills aren't valid. Okay. Another time we get to see you.
Also, on the PC 200, you have to identify who are the heirs of the person who died, starting with the spouse, and then identify the children, and then identify possible grandchildren or siblings. And you may even have to furnish a family tree if it doesn't meet the statutory requirements in terms of that.
That's a very good point, and that's because we want to make sure that people have an opportunity to come in and say whether they object to the introduction of that will, or whether they have another will, or whether they approve of it. So you want to give them fair notice of what's going on.
And then if I recall the form correctly, the next section says, are there beneficiaries named in the will, and where are they named? What's the section, and what's the paragraph, and where is it? And are any of the assets, I think the next question is, held in trust, and are there trusts, and where are they? Because as you just rightfully pointed out, Judge, we really do want to give people who may have an interest in the estate assets opportunity to know about them and to be heard, and to make decisions that affect that particular decedent.
And then if the will is admitted, an executor is appointed.
Yep.
If there's no will, we appoint an administrator. Somebody is named as the administrator. Same.
And if there's real
Yeah.
estate,
And
there's another certificate.
So you get this one's an important one. So
It is.
the court will send out a certificate that notice for the land records as to who the executor or the administrator is for the estate, and that needs to get filed on the land records.
Yeah.
It's the same $60 filing fee paid to the West Hartford town clerk's office.
Yep.
But that notice provides third parties
Yeah.
Notice that somebody has died, and that if you have a claim or you have an inquiry that relative to this particular piece of property, it would be prudent upon them to reach out to this person who's been appointed the fiduciary in this particular matter.
Right. Right.
And then after that, what would you file? Just briefly.
2 months later, you file within 2 months an inventory of PC 440.
Yep. And 150 days from the date of appointment, you have to file the list of claims.
PC
And-
237.
Thank you.
Which are claims against the estate.
Right.
And if everything has been accounted for, you can prepare an accounting, your final accounting, which is subject to the review and approval of the probate court.
And during the process, should you wish to sell the property, and the person had a provision in the will that didn't say anything about selling property, you would have to file a petition with the probate court to get authority to sell the property.
Or if you are an administrator and there is no will, you have to come to court and ask for permission to sell the property.
Yeah.
The court is going to look at how you valued the property, make sure that the valuation is fair. They're going to look at who's buying the property. If it's somebody on the inside, in other words, the administrator might be buying the property, or
A friend.
you really want to make sure that the process is fair.
Yep.
And have the court approve that sale. And you do that by bringing in either appraisals or fair market analysis done by a realtor or someone who has some expertise in that area.
And early in the process, when I file a PC 200, I like to also file an extension for the 706 NT, because you have to file it within 6 months unless you get an extension, which would grant you another 6 months. So I like to get that done immediately so you don't miss that deadline. And that will cause no extra interest or fees to be assessed against the estate.
Well, I see our time is running out here. I want to thank Leanne and Marianne for coming today and imparting your great knowledge on the audience. Thank you all for tuning in. Thank you, Jen Evans and the staff at Channel 5. I hope you join us again for the Probate Court and You. Thank you all. Have a great day.